All meeting to order, stand for pledge allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. For a motion to approve the agenda.
I will make that motion.
I'll second that. Motion and second. Any further discussion? All in favor?
Aye.
Opposed?
I make a motion to approve the minutes for July 29th.
I will second that.
Motion and second. Any further discussion? All those in favor?
Aye.
Opposed? Need a motion to approve claims for August 4th.
I've reviewed the claims. I'll make a motion to approve for the amount of $208,244.85.
Second that.
Motion and second. Any further discussion? All those in favor?
Aye.
Opposed? Okay, discussion and possible action to approve resolution 202638 Cripple Creek Farm subdivision. Who's gonna tell us about that?
Oh, well, he's not gonna jump up a warm.
Yeah, that's the one I showed you the beginning there.
Yeah. Little kind of land.
It's not a building site, it's just something that they added on to it, that since the parcels are split so many times, that's what created the subdivision on it.
It's not. Little triangle right there.
Right there.
Oops. So they're adding, or
So they're actually just family members too. So originally they thought they were supposed to have that, so that's what they're doing now.
so they're adding it to their parcel, is that what they're doing?
So they're taking it from the Schaefer's right here, and the Barton Hayers parcel right here.
A lot of land we're talking about.
It's not, I mean,
Ain't even a football field.
the rules is what made it a subdivision, even though it's not buildable, it's just part of the land to go with it. But it's been approved and everything for everybody on mine.
Well, if that's the truth, I'll go ahead and make a motion to accept resolution 202638 Cripple Creek Farm subdivision.
I'll second that.
Yeah, motion and a second. Is there any further discussion? All those in favor?
Aye.
Opposed? I'm signing this here, and is this the one I'm stamping?
Yeah, that's everything.
Yeah, and then you're gonna notarize it.
Yep, I have it in my car.
The date right?
Yeah, I changed.
Okay.
If I'm right, it's August 4th. Isn't it?
Yeah,
2025.
There's a page missing. Why is it all on that here?
I was doing.
Thank you.
You have everything.
Maybe we can have that back.
That time, they.
They contacted me, I talked to them on the phone.
There you go.
Did you never know that?
Okay, there you go, sir.
Thank you very much.
Yeah.
Have a nice night.
You can bring that check.
I'll get that to you tomorrow.
Okay.
You taking it, right?
So next item on the agenda is discussion on possible
Thank you.
action to approve the resolution 202639 property subdivision.
That's this one. There it is on the beacon. This is what it's gonna look like. And you can see how they kind of cut this right here to give it the 2 acres. That's well, that's Big Buck Farms, but Dog Time LLC, this is Bob McCully's. And I didn't really understand it because this was a 5 acre parcel, but then once I talked to them about it. There's a pivot.
So,
So, they want to save, they want to get rid of the house, but they want the land, so that's the reason. This parcel's been split on two, this is the third, now it's gonna be split. So that's the reason for the subdivision, is they want the land. Not that, you can build on it eventually, I suppose, but right now,
they're taking the house out just
they're taking it, they're selling it.
while we're selling it.
I've already did the time transfer and everything on it, so.
That's what they're doing here.
Yeah.
This parcel off,
This is the whole five.
this parcel off the house.
Yep,
There's somewhere across here, it's gonna be kind of like,
yep, you can see
Yeah.
exactly, yep, exactly. And that was getting approved by everybody too, on my end. Okay. And she's got all the paperwork on it, but somebody was supposed to be here, but
Something's supposed to be here, but
So can we still approve it or are we?
we could still approve it, but they ain't gonna get nothing until they,
yeah,
they won't be able to report it or nothing.
no, I'll hold all the paperwork
Yeah.
until everything. I have more paperwork over here.
So you have the maps there then?
Yeah. Do you need to look at it?
No.
Pretty much the same as a.
Yeah.
Vote, right?
you wanna make a motion, Scott?
Yeah, I'll make a motion to approve resolution 202-639 Crawford subdivision.
I'll second that.
Okay, we have a motion and we have a second. Any further discussion? Not all those in favor?
Aye.
Those? No one has signed.
Yes.
Number 7. Discussion and possible action to appoint 2 alternates to the Board of Adjustments. Namely Chris Boyd and Mark Spitznow.
Mark's gonna be, depending on if he passes, or not passes, but he has to take the class yet that we're all required to do. I've gotten some of that didn't have to. I've been keeping their certificates in my file. He knows it's coming up, I think it's the 17th of this month. He knows that he's gotta take it. That's gonna be the other stipulation for him. In order to be there, he has to take that class.
Yeah.
The other one's all right to go. He was on the last one as an alternate. I just feel that I need to have 5 people there and it always happens, something,
Yeah,
some accident or something will happen and I don't have the 5 people. What I need for my meeting on, I'm tentatively looking at September 1st. So that's the reason I asked. They both volunteered to be on, so if they're all right with you guys, I'd like to have them as alternates for the rest of the year. Which will be until January, and probably just try to set myself up in the next year to keep an alternate on hand, and they're both on planning and zoning. And right now, it would work out good that I have both of them.
so
I'll make a motion to, do we need a motion for that, Tim?
I put it on as motion.
Okay, I'll make a motion that we appoint the 2 alternatives to the Board of Adjustment, Chris Boyd and Mark Spitznow.
I'll second that.
motion and a second. Any further discussion? All those in favor?
Aye.
Those? Item number 8, we need to go into the public hearing.
Yeah, wait for 6:15.
What do you think?
Thank you, Brian.
Thank you. Do you want this stuff until like nine for the shop or just?
You want me to, I'll take it. If you want to handle it, that's fine.
I mean,
Make it kind of me.
Okay.
My,
They got
they
to
was
do it.
supposed to be here. They told me that they was gonna be here on the phone, so.
okay. That way I don't accidentally do anything with it.
That's fine. I'll
Okay.
put it in my office and then they can try to hand me down.
Sounds good. Thank you.
It's a little difficult right now. but
Yeah.
If they do, we'll do.
I'll let them know you have it.
Thank you. See y'all.
Bye. Thank you.
Give meetings tentative if you want.
Yep.
Right, well,
Works for me.
we'll do that. Move down to 18 real quick.
Yep.
Had a Louisa County Conservation meeting, last night. Nothing too major. We went over the fiscal year 26 annual report. They do have some auction items that they're putting together to have an auction. They were gonna get together with the roads department, see if they had anything. And I think public health has a car that they are gonna get rid of. So that should be coming up on September 12th at 10 a.m. Bill was polite enough to do the crying for us, and conservation will do all the paperwork. So, we did have some water issues this morning at the complex, I understand. I haven't heard if they're rectified yet. Low water pressure. They did change all the median to filters last week. I don't think it's related, but when I find out the answer, I'll let you guys know. And I checked on our new air compressor last week. It's working fine. It was a little low on oil, so I stayed up on that and I did some maintenance on it. So I think that's what killed the last one. It ran and ran until it ran out of oil and then it locked up. So I'm just keeping an eye on this one. Other than that, that's all I have.
I didn't have anything last year.
You mowed?
One vote.
Thank you.
Thanks for mowing.
Yeah.
We had a meeting down at Burlington this week, the community action. Gary, who has been there for 29 years, and been director, is retiring. So they had their top candidates replace her, and then we got a chance to go down and meet with him and ask questions, and it seems like he's probably a good pick. He's out of Michigan, relocated to Burlington because he's got kids here, so. Other than that, I didn't have,
Would be possible if I'm just gonna, Brian T has all the paperwork.
It's taking the court, I didn't know you know.
Oh, so I was
What do you need me to do? I can sign.
just contact Brian T. He's
No,
got all the paperwork.
he already took off.
Mhm. Sorry, do you have a cell number?
Yeah.
Okay, yeah.
Well-
He just left,
Maybe I could cancel you.
yeah,
I don't
because you gotta pay him, so
like all.
Money talks.
you can just step out. Oh, oh,
I'm sorry, but
It's all right. We got several minutes for our next thing anyway.
here you go. You're welcome.
Helen, I have a question. When there's a building permit issued, or there is for the county, right? Certain things, building permits. Who reviews those or approves them, disapproves them?
Brian, he,
Ron T?
Yeah.
Do you guys ever get in there on them? It never comes up in these meetings, so I just wonder.
No. If there's a dispute about something, then that's when the Board of Adjustments comes in. So Brian can deny one or approve one. If he denies one, and somebody wants to proceed further with it, they can take it to the Board of Adjustments. So,
So he determines if it fits the criteria totally on his own.
right, because he's our zoning administrator, so he
And those don't get into the minutes of the meeting or anything, do they, for the public?
I don't think so.
I don't know if those meetings are open to the public or.
Oh, they should be.
They would, I
Mhm.
think so.
Every month,
Yeah, I think anybody could just.
second Tuesday of every month, it's right after our public health meeting. You always see
And
us.
their agenda's published then, so somebody would know what's coming up.
Mhm. They meet over at the courthouse, generally in the courtroom.
Posted on the website.
Susan said she posted on her website, so you can check it there, so. I think it's 6:15.
Yeah, yep.
Okay.
Yeah.
So. Do we need a motion to open public hearing?
Yep, I'll make a motion to open a public hearing on non-exclusive access easement.
I'll second that.
A motion and a second, and we need a roll call. Is that right?
Yes. Maine,
Here.
Hunt,
Here.
Harden,
Here,
and Snuffler here.
okay. We're in a public meeting. I guess we're ready for public input.
I got the answer, I don't have the input.
So it appears maybe we have no public input.
Do you want to stand up at the podium?
Podium, yeah.
Yeah.
That way it goes in the mic, yeah.
Hi, I'm Luann Timmerman, and I'm objecting to the resolution 202-637. And I would like to read the deed restrictions and regulations on FEMA Lot 6 that the county signed onto to get the 2008 grants for the flood, which is attached and recorded with Lot 6.
I can't.
Terms pursuant to the terms of HMGP program statutory authorities, federal program requirements consistent with 44 CFR Part 80, the grant agreement, and the state local agreement, the following conditions and restrictions shall apply in perpetuity to the property described in the attached deed and acquired by the grantee pursuant to FEMA program requirements concerning the acquisition of property for open space requirements. I'm going to go to transfers and deed. The grantee, including successors in interest, shall convey any interest in the property only if the FEMA regional administrator through the state gives prior written approval of the transfer in accordance with this paragraph. The request by the grantee through the state to the FEMA regional administrator must include a signed statement from the proposed transferee that it acknowledges and agrees to be bound by the terms of this section and documentation of its status as a qualified conservation organization if applicable. 2, the grantee may convey a property interest only to a public entity or to a qualified conservation organization. However, the grantee may convey an easement or lease to a private individual or entity for purposes compatible with the uses described in paragraph A of this section, with the prior approval of the FEMA regional administrator, and so long as the conveyance does not include authority to control and enforce the terms and conditions of this section. An inspection, FEMA, its representatives, and assignees, including the state or tribe, shall have the right to enter upon the property at reasonable times and with reasonable notice for the purpose of inspecting the property to ensure compliance with the terms of this part, the property conveyance of the grant award, monitoring and reporting. Every 3 years, on July 1st, the grantee or the mitigation grant program subgrantee, in coordination with any current successors in interest, shall submit through the state to the FEMA regional administrator a report certifying that the grantee has inspected the property within the month preceding the report, and that the property continues to be maintained consistent with the provisions of 44 CFR Part 80, the property conveyance, and the grant award enforcement. The grantee or the mitigation grant program sub-grantee, the state, FEMA, and the respective representatives, successors, and assigns are responsible for taking measures to bring the property back into compliance if the property is not maintained according to the terms of 44 CFR Part 80, the property conveyance, and the grant award. The relative rights and responsibilities of FEMA, the state, the grantee, and the sub-grant and subsequent holders of the property interest at the time of enforcement shall include the following. The state will notify the grantee and any current holder of the property interest in writing and advise them that they have 60 days to correct the violation. If the grantee or any current holder of the property interest fails to demonstrate a good faith effort to come into compliance with the terms of the grant within a 60-day period, the state shall enforce the terms of the grant by taking any measures it deems appropriate, including but not limited to bringing in an action at law or in equity in a court of competent jurisdiction. FEMA, its representatives, and assignees may enforce the terms of the grant by taking any measures it deems appropriate, including but not limited to one or more of the following: withholding FEMA mitigation awards or assistance from the state or tribe and grantee and current holder of the property interest. And then I would just like to read a few things from the judge's order that the county cites as a reason is giving this resolution today. On page 16 of the judge's order, he says it was not contested that Louisa County is the owner of Lot 6 in Block 1, and that the deed to Lot 6 has restrictions regarding its use and limitations as to who it could be transferred to. This appeared to be the result of the county's participation in a federal program. The federal government, through FEMA, could assert a great deal of control over what could be done with the property. FEMA had a right to inspection, to dictate its use, and determine what can and cannot be built upon it, upon other restrictions. And he says, as to Louisa County, there was competent testimony from Mr. Poggemiller that there were discussions and an agreement with Louisa County that the respondents could cross over the lot following the conclusion of this action, and the respondents obtained the easement. There would also be payment of $500 by the respondents to the county. When Louisa County is referenced, the court assumed this was the Board of Supervisors. It has also been conclusively shown that Louisa County was aware of this action and negotiated a settlement depending on the outcome of this litigation. The petition, and then it says the county and FEMA were not given notice. The action against the petitioners, that was us in this case, would not be invalidated. However, the county and FEMA would not be precluded from challenging an action affecting land they may have an interest in. See also recondemnation of land for Valley Park Aquatic Roadway, 687 North W2D 105, and Iowa case 2004. So then I just have a few questions after reading those regulations. Has the county, under these rules, ever contacted FEMA at any point or time to notify FEMA of the condemnation of eminent domain rights in land on Lot 6? Has the county contacted or gotten written approval from the FEMA General Administrator prior or at any time before the arrangement and the payment to the county? And would the county be compromised in future grants under the notification and easement part in the 8019 regulations by not explicitly following them? That's all I have. Thank you.
I
I'm Richard Timmerman. I own property in Elric. I own the entirety of the old town of Elric. And I also own all the streets and alleys down there. There's been a lot of talk about access, FEMA properties. What's the use of FEMA properties? This county has tried to lease these lots out before several different times, and it's never worked out for you. The county attorney says it's been a contentious few years down there, and it sure has been. There's several reports of trespassing that have gone unanswered. We've been assaulted by Mr. Miller and his sons. My wife's been punched in the face, and I took the rest of the beating from the other three of them. Now, couldn't obtain the videos that they took, but they didn't have a problem showing them in court, which is public record. All it shows is one guy hitting my wife and the three of them beating up on a disabled person. And that's who you want to give leases to across the property. And you don't think that that's going to antagonize or exacerbate the issues going on. As a matter of fact, you've opened up a whole Pandora's box of that all over the county. You've got people already coming in and demanding lots. The whole deal was with leasing those lots was a deal for people who were contiguous to the property only, and either that or surrounded the FEMA properties were allowed to do that, lease the lots. And that was to stop other people that had no interest in the lots from going out and putting a tent in the middle of Scott's field. Those were the guidelines in the past. Are those still the guidelines today?
You're asking us?
I'm looking right at you now.
Right.
Is that the,
I don't know,
Those
what
rules.
question are you asking?
are those the same rules that were followed in 2001?
I can't answer that question, I don't know.
And is this a non-exclusive easement arrangement? Is that have a time limit on it? Is that yearly? Is that gonna run consecutively with that property?
We'd have to read the paperwork that I don't have in front of me.
And as far as the director of FEMA is concerned, at any time were these suggested to him or made known to him that the county had allowed condemnation, multiple condemnations across that property, where the court has given control, apparently, to Mr. Schultz and Mr. Pogmiller, which is a violation in mitigation rules, as you probably well know.
Are we arguing that this isn't a court of order? I'm not here to argue
It's
the
not.
legality of that tonight. You can state what you want, but I don't know that we're here to hear arguments about that.
Well, these are questions that should be answered by the FEMA director.
But wasn't this directed by a court order? Was it not?
No.
Did she not just
The
state?
court order doesn't say the county has any obligation to do anything. It does have 8 pages of chastising the county for the mistakes they've made. But it doesn't say anything the lease has to be given to
Doesn't
the
say,
party.
can't say we can't though.
Well, it doesn't say that you can, but there are rules and things that you should consider
Fair enough.
long before you do it, and this is not the property of superintendents or the county. This is the property being held for the citizens of the county and the state of Iowa. And these are a more robust conversation and information than this one meeting is gonna produce. Also, in the decision, because in the floodplain, there's not just floodplain, but there's also in the floodway, which is more, there's had more restrictions than just being in the floodplain. Also in the floodplain, to do anything, you need permits. You need to talk to DNR. They have talked to DNR on their first application to go through there, which was in the creek, which that's entirely their fault. They had, if they would have followed any of the rules that the county would have had them to condemn, they would have had surveys done, they would have had all kinds of things done before they put the cart before the horse. Before taking somebody's property, they should have known if that property was usable or not. We had the letter from the Iowa Department of Natural Resources back in March 25th of 24. We had the representative come down. We didn't have the Phi Excavating did because of request to build a road to the property, which is part of the rules of condemnation. I believe it's even some of the county rules on that. And that road was going to cost them somewhere around $500,000. But that's for the entirety of the property. It's not just in the section, but that was in the creek. And so, to my knowledge, there has not been any other request for information or a permit from the natural resources. And I can read this, it's only a few pages, but it says that it's not only in the floodplain that they're required to have permits. It would be from the Corps of Natural Resources and U.S. Corps of Engineers. Because as far as I know, the request on the condemnation now is the western 40 feet of lots 1 and 2 that will continue on through my property. Well, 20 feet of that 40 feet was still in that creek. And so it's been denied once. And not just in the creek, in the surrounding area. The surrounding area was its watershed, of course, and it dumps. Creek drains 25.04 square miles from an unincorporated area. Confluence of small tributary along Spring Street. He was on the property and inspected it for John Schultz at Pogo Miller, and they received the answer that it would more than likely be denied if they proceeded. So there goes the second, third, fourth condemnations. The pictures that you were probably looking at, that you said was a weed mess in my property. Were these the pictures you looked at? These
I
are,
don't know that I ever called it a weed mess.
I believe that you did. And
I don't
video,
believe that came out of my mouth, but.
video,
Okay.
video
Okay,
doesn't lie.
you say so.
I'm not, but I'm not
I'm gonna
I'm not
argue.
disparaging your character on it. Just that's the way it appeared to you in the pictures, and that's I can see that. Because this is down actually in the creek. Where obviously when the sheriff's commission was down there, every person on that commission was down in that creek. And they knew exactly where they were and what that survey said and where they were gonna be. Pogue Miller said, or his excuse is that they didn't know. Everybody knew. Their own attorney, Roger Huddle, was in that creek. And so the excuse of not knowing it until a later time is that's a fabrication. One thing that you guys haven't heard about this, because all it's been is condemnation. But condemnation doesn't just come out of thin air. At first, as you should recall, they claimed they had easements, which the county sold to me. And so that stopped them, the sale of those streets, stopped them from accessing the property. And so they took that claim to court, and the decision on those easements were that they didn't have any, never maintained any. They fulfilled none of the elements of any of the four reasons, which they only took to court two. And nothing on the other two. And honey, you got that paper, please. And it gives a description of each of the easements, prescriptive, necessity. And what they would have needed to done to have claimed the easements. One thing that it does show and say, besides that their claims were denied, is that Mr. Pogermiller was trying to adversely possess my property. And what that entails is that not only would it be I have an easement access across your property, but they take title to your property. And so he was trying to steal our property before anything else. And the judge notes that when it became aware of it, it was not until 2 years ago when Pogemiller was charged with trespass that Timmerman had noticed that at least Pogemiller was asserting the claim of right to the lane. Since that time, Timmerman has made it clear that neither Pogemiller nor Schultz have the right to use it. As soon as Timmerman was aware of Pogemiller's making the claim of right, he put a stop to it. Based upon the foregoing, the court cannot find that Pogemiller and Schultz have proven that Timmerman had expressed notice of the claim of right of the easement, separate from the mere use of the lane, against the objections or protests of Timmerman. Consequently, they have failed to establish elements necessary for an easement by prescription.
That's the easement over your property. What does that have to do with this?
Because these are the excuses that he's used to
Yeah, but
bend your ear for the last 5 years.
again, that was on your property, not this property.
These
Yes,
are,
it does. It goes through lot 6.
it goes through lot 6.
It always has. So it's the
Yeah.
First Nation. It's always
There-
gone.
There's
through
never
lot
been a
6.
road through there. There's always been lots. Always.
It's always gone through the FEMA lot.
And I would suggest, because apparently there's gonna be more action by Mr. Pogemiller on that road in a couple of weeks, that sure that you're aware of. And so I would suggest that the board table any decision they intend to make today and have at least 2 more public meetings on, this is a serious issue. And it doesn't just involve us, this involves everybody in the county. Because you've unleashed the dogs. Now it's because of your budget shortfalls that you're gonna use that, but you've also said that you want to put them back on the tax rolls. You cannot put those lots on the tax rolls. Also, the lease money that you intend to receive from these lots, you say are going to pay the taxes on the lots. Well, those taxes were paid when the lots were sold. And they've been exempt ever since. And so when you're telling the public that it's gonna go to pay the taxes on the lots that you're paying, that's not accurate, is it?
So what's your suggestion? Just leave them there in
I would suggest that,
limbo and let them grow up and just ignore them?
because, you're not taking into account of the people that have taken those lots, maintained them,
Yes,
have
we are.
done your job.
No, you're wrong.
Done your
We
job.
are. We are.
I'm not saying, I'm not laying claim to
Okay,
the FEMA lots.
okay.
I'm saying that I have maintained
I understand.
several of them for 30
I
years,
understand.
and the ones that.
But
that
you're accusing us of not taking care of the landowners that are already there, and we have. So you.
I'm
you
not,
don't-
no,
you don't
no,
know
no,
what we've done.
no. I
I'm
am
not talking
saying,
about your property. You don't own all the FEMA lots in Louisa.
I don't own any FEMA
Okay.
lots.
So there are other FEMA lots with other adjoining people within the county that we have talked to that you're not privy to. So you're kind of lumping it all together here, and that's not
These,
true.
these lots were supposed to be maintained. Now, the only things that I've heard anybody ever complain about is the Reggie Meyer edition of all the expense you had up there. Kevin himself said they're so far behind on the mitigation, on the maintenance of those, that it would cost. And that's true, because you are behind on it. You're way behind on it. I'm not saying that that's particularly, your fault, new board, you know, you have to delegate those things out, and you don't have the money for it. But you've also accepted money and rules for that money, for those grants, for the county, for the people. Now you're putting all that in jeopardy.
No, not necessarily. We're following the rules.
There are so many
I
rules.
know there are. We've talked to
This,
council about it.
that-
We've got direction on it. So,
We believe you. But the board is allowed the condemnation of that lot 6 and not reporting it to the region 7 manager. That you're violating mitigation rules.
we heard you.
I will say, looking through here, that if we pass this, it has to be consented to by Federal Emergency Management Agency, and its regional director have to sign this. So,
And so we believe that this needs to be tabled until there's more discussion,
It says prior.
and it does say prior. But this needs to be tabled to where it can be discussed more openly in the public.
And the county was supposed to report it to the FEMA administrator. It's been taken by eminent domain to condemnation, lot 6.
And that's given,
And as the county, as the grantee,
which is
and
giving them
after-
authority over you, actually.
nothing was reported. Instead, you entered into an agreement for payment.
The paperwork
Another
that's in
part.
front of me says it's non-exclusive.
Oh, that's how you're getting around it.
No, wait a minute. When it says non-exclusive, it doesn't mean that
Does it have a name?
him can go down. It says non-exclusive.
But you're still, the county is still transferring their interest in lot 6.
You're allowed the court to take the power, the authority that you have, and give it to him, because you motioned, made a motion and 10/1/24. Ball stepped out, recused himself. He'd been named as a party. Mr. Parsons came in to advise you. And you told him, you want no part of it, stay away with a 10-foot pole.
I did.
And there was.
Made the motion, second.
Because that had happened 10 years ago, and I didn't want to get
No,
sucked
that
into
was-
what I'm getting sucked into
That was 2020.
right now.
That was
That's
2 years ago.
2024.
That was 2024.
That's 2024.
I know that. all this started way before that.
But
Yeah.
the county's interest started in around 1024. Parsons advised you. There was even talk in the background of the contacting FEMA. And apparently
It
that
wasn't
was
done
done.
because it had a 30-day response to the petition.
Okay.
And Mr. Parsons didn't believe that he would have the answer he needed from the regional director within the 30 days. But that's been 3 years and
Mhm.
some odd months ago.
Mhm.
And has he been contacted for any of this?
Not to my knowledge.
Why is that?
I don't know.
Do you have oversight over these?
We do, but I don't oversight every single thing. We have people in place that are supposed to direct us and give us advice to how to do this.
Would you
FEMA
admit
has oversight.
FEMA has the oversight, but you negated
It's a 3-year agreement,
that
compliance.
authority
with them every
and
3
you-
years.
let
So it's not in compliance.
the individual condemn cross that lot. And now he has authority over you. He told you last week, he doesn't care, doesn't need it, doesn't need your approval. Does he need your approval or does he not?
I don't know, that's a question for Adam. I mean,
I think there's several questions, and if this is more out in the public and a couple more meetings, maybe we'll have the answers for that.
Perhaps.
And I guess regarding any communications, has this board had any communications with Mr. Pogmiller, his attorney, on any kind of secret deals, any kind of deal you've worked out?
not that I know of.
Are you aware of this letter?
I'm sure I did.
Are you aware of this letter?
I'm not.
My attorney got this from supervisor meeting when we attended it.
May have, I don't know what letter you're referring to. I get a lot of letters, so.
At any rate, I'll just read the one sentence in here that really means it to me. This will confirm that offer, and out of an abundance of caution, provide to you by ordinary mail a copy of the document that will be assessed, hearing it is necessary for us to seek appraisement for damages for the county for our condemnation. And this is asking for a favor from the county.
From Pogmiller's attorney.
Pogmiller's attorney asking for a favor that has apparently been done.
I'm not aware of that letter, so,
You're not aware of it.
no.
Are you aware of any other communications?
I
Email?
mean,
Very
who was that sent to, Rick?
Well, I got it from the supervisor's office. I got it from here. Our attorney got it from here
It was
after he was done speaking.
Gray, Pogmiller, Schultz's attorney, to Adam Parsons.
And it has, this is on 17th to 2025, and it says also that she had a communication emailed on September 2nd, 2025, on an ongoing condemnation case, which to me reaches ex parte communications, and that's never good, fellas, never good. We can continue, and we can talk about the email that we FOIA reported from the county engineer, and those discussions on how she wanted the county to proceed and what she needed done,
And prosecution
and
of
prosecution of us of basically when they play ball and use the system. Don't know about any of those.
No, I am not aware of any of
No.
that.
And
No, Adam Shutt never suggested prosecution of you. That was between Ms.
This-
Gray and Adam Parsons.
and Mr. Parsons. When they took down the gate and the fencing that had been transferred into Ball's name. This Spring Street belongs to Ball, didn't belong to the county. The county had no legal right to remove anything. Whether it be mine or Ball's, Jim Farms, however you want to say it. Now, I don't hold nothing against Adam for doing it. He was following the direction, I'm sure, the county attorney and the board.
You're looking at me, I don't recall telling anybody to take on the fence, so
And nobody consulted us about anything.
you're trying to keyhole us into.
No, I'm not trying to intimidate.
We're enemies here, and I'm here to tell you.
When we came in here, we agreed with the county position that they were not involved in doing anything. But you were involved in doing things. Maybe not you personally. But you have a county attorney that's been working behind the scenes then.
All right, so we,
But we're not gonna here to run everybody down the ground. What we like for you to do is table your decisions, till you have everything under control. And that you have answers from the regional manager and all applicable laws are followed and considered with DNR requirements. The whole thing's floodplain down there that says that not just the creek, but the area. That is not gonna allow that.
so would you objected and then like to table it and,
Yeah, I'm objecting to it. I would ask you to table it and consider having
right,
at least up 2 more public meetings for input. And that gives you time to go over any rules that you may have missed before that's done. And we'd appreciate that. And thank you for your time, fellas.
I'd like to thank you.
Yep. Thank you for your input, we
I
appreciate
just
it.
have some of the information
Okay.
that you were discussing.
Thank you.
And thank you for your time. Everything's all public information. Thank you.
Not enough, and ask the question.
Thank you.
Oh, well. Gee, I guess I'm gonna have to talk a little later.
That's the podium.
Well,
Yeah, get up here.
Well,
I am, I'm just thinking, well, I want him to go first or me to go first. If I can ask him a question. I think I'll go. And I'll make this as short as I can, which is still gonna be an hour and a half, but. That's a joke. Anyway, this thing started, 6 years ago, whatever it was. And it started out, we was gonna condemn from, I call it K Road up through there. And we went there and the first judge says, no, you can't do this, you're gonna have to condemn it. What we was after was trying to get an easement through there without condemning it. Can't do that. Wasn't trying to steal property. Just trying to go back to my land, John Schultz too. When I talk me, John Schultz has land back there too. So we went through that and we got the first order back after we condemned it. Said, yep, you got it. Runs along the section line 40 feet out. Nobody knew where the section line was. It's in that creek, we just don't know how far. So 40 feet is a hell of a ways when you gotta start here and you get a car around it. So we lived with that for a while. And then we decided, well, we can't use that. So that's when things started, and actually before we said we couldn't use it, now we got different property owners in it. We got the county in it. We got Spring Street in it. We got the railroad over right of way down there in it. So we got to decide all this. So we ended up hiring a surveyor, surveying it. The courthouse over here, Ball says he's got property there. Courthouse shows him paying no taxes on anything back there for 100 and some years, or whatever he owned it, 30, 40, 50 years. So how would we know Ball owned that? All of a sudden out of woodwork, and he's been to these courts, he comes up and goes, oh yeah, I own some. So I don't know what the taxes, how he missed the taxes on that, don't care, that's not my problem. But he ended up owning a 20 feet by 50 feet or whatever it was. So here we go back to court. 5 or 6 times we went back to court. Every one of them ruled back in our direction. The sewer was taken care of. Spring Street's taken care of now. Ball's taken care of. gates down on county property. It's all taken care of. He had 30 days to appeal this last one and he didn't do it. I come in here when this first started thinking the county board, different board, you might have been on it, could give some insight and some knowledge, and let's see if we can work this out. They said they was gonna stay out of it. Well, they can only stay out of it so long when the feds call you up for this, but anyway, I get that, I get that. Now, some of the stuff he's saying, it's already been in court and proven. It's done. We got the final thing. He had 30 days to do it. It is what it is, and it's gonna stand there. Every one of them we wanted. I have a restraining order against him when he says that he's been abused or whatever he's been. It was me. And I got witnesses. I don't go back there unless I got a witness. I can bring 6 of them here, how many times he hit me. This guy and his wife comes running out there with phone cameras. I don't even know how to work a camera on my phone. And they take pictures. So if there was one iota thing we did wrong, and they got cameras hanging everywhere, but one iota thing we did wrong, he'd have it on film. And he'd never showed any. In fact, this wife hitting thing, we showed a judge in court. The film I actually took that I don't know, I got one of them monitors like the police have and put it on there. Problem is, when you turn your head, your body don't turn. So I'm not a good film taker, but we had enough to, we wasn't within 40 yards of his wife. So I don't know where this come up, but it's a good story and people believe it. But this is what we've been going through, all them papers he had, like I say, the papers that he had in court, and they try to get it across a different place in the correct to make one of them Missouri crossings. That failed. Everything they've done has failed. Now, in my eyes, and I've told you this before, from that lot 6 down to the K road, I don't know why we was fighting over that to begin with. The county has to have a way to lot 6. If he's talking about public using that, he don't want nobody back there. I don't care who goes back there. There's a pretty scenes back there now. I really don't care.
That's why I brought up the.
And I don't think we can stop him going across the public. I don't know if we can stop him going down the easement. I don't care. But if somebody asks me permission, I'm gonna say, yeah, go ahead, because there's not much of there's a lot of stuff going back there. I don't care. But I think I rented lot 6, tell you the truth, because I paid $500 to the county so we could use county land. Is that not correct, sir?
Person.
Yes or no would do.
It's a public hearing. Normally at a public hearing, people express their public input, usually time limited.
I guess I'm asking you a question you wanted me to ask.
Closed. I don't answer questions unless the board asks me to answer a question.
Well, anyway, we paid $500 to you to get across that a lot that I would pay taxes on. I'm not sure why that is, so I'm kind of waiting to see what happens to other public land. But anyhow, so that's that. I thought it was a done deal when we got a quarter right, and I think it is. A judge usually rules, and that's what it is, because when they don't, it's out of my hands, and I'll tell you that. Like I say, he had 30 days to appeal it. So if there's any questions you want to ask me about anything there, I went through it pretty fast, but that's 6 or 7 years I ain't gonna get back. And don't get me wrong, it's not over. You go down there, there's always something across the road. There's thorns in the road. And you can't get the sheriff's department to do anything about it. Well, we don't know who did it. Come on. But we're working with it. We're working with it. Is that it? That's all you got for me?
Thank you.
Thanks for your time.
Yep, thank you.
Anybody else got anything?
Well, that's not an okay. He said he don't ask a question, but he wanted me to ask him one to begin with, and that was, so what do you read into this court order? What do you read into what the county's rights are?
Let's get out of the public
Yeah.
hearing and let's get into regular discussion.
Huh?
Let's get out of the public hearing and into regular discussion.
Okay.
Because Adam's right, we're here just to hear public.
No more public input. I would entertain a motion to close public hearing.
I'll make a motion to close the public hearing.
I'll second that.
Any further discussion? All in favor?
Aye.
Opposed? Okay,
Now we're in regular.
now we're back in regular session.
You're on item number 9.
Item number 9, which is the discussion and possible approval of this resolution 202637 for a non-exclusive access easement.
I have a question for Adam.
Yep.
Do you think it would be in our best interest to contact FEMA?
Can you
And-
talk a little louder?
Sure. Would it be in our best interest to contact the FEMA director? Because that seemed to be a big thing with him, and if we got his approval, then that would take that off the table.
That's the one piece of Timmerman's presentation or public input that I think is important to do. The document, as Kevin pointed out, does provide that it has to be signed by the FEMA regional administrator. So my recommendation is based on the court ruling, is that the board either approve the resolution subject to the approval of the FEMA administrator and then wait to sign everything until they've signed off, or hold off on, we've completed the public hearing, we don't have to do that again. So hold off on the approval of the resolution until we do have a letter back or something from FEMA. I have attempted to contact the FEMA regional administrator in the past with questions. I've never received a response back. On this permission issue, my understanding, maybe wrongfully, was that Elaine Gray, attorney for Pokemon and Schultz, was going to contact the FEMA administrator and get permission, and also contact me to get the board's permission. I have not received anything from Elaine that says she did get the FEMA administrator's permission. So if the board wants to hold off until that's done, that's would be appropriate.
I would like to do that, and I would put in the letter that if there is no response, we assume that it's okay.
Now, before you vote on this, I'd like to say, number one, the judge ruled on that part.
I
He
understand.
said FEMA didn't
I
answer, and if
understand.
they wanted to answer, they would have answered, so he's
I
kind of taking
understand.
that bluff there.
I'm
Number two
trying
is,
to
but
shore up
number
all
two
loose
is,
ends.
Well, the judge also noted that FEMA wasn't served with notice, so they wouldn't know about it.
they tried to contact him numerous
I
times.
understand that.
But number two is, now you're giving him false hopes to where he closes that road all the time. Yeah, because he's gonna say, and he's gonna back him, he's gonna say, well, we really haven't come to a conclusion yet, so let's just hold off of you guys going back there.
But another week or 10 days isn't gonna make any
We
difference.
got the court order, buddy, and I'm going back there.
Okay.
So,
So-
for the history for that, there have been dueling criminal complaints from the Timmermans and Mr. Pogler and Mr. Schultz over the past several years, which the sheriff and I have handled when we could without board input. One of those complaints involved Mr. Timmerman putting up a fence, essentially, or a gate, blocking the Schultz Timmerman easement access, not at the FEMA lot, but earlier. He was told that he would have to tear that down pursuant to the court order, or at least open it up. Otherwise, he would be charged with a crime or potentially contempt from violating the court's order. That issue got resolved. I don't remember if secondary roads took that gate down or if,
Yes, we were under the impression that it was a road because everybody had wanted it to be a road until they didn't want it to be a road. And then I was made aware, I believe, by one of the attorneys that perhaps it was never recorded as a road. And once-
after the gate was taken.
after the gate was down, and then once it was made aware to us that it wasn't a road, we had an option to go with a prescriptive easement or something like that, and declare it a road, but we decided to stay out of that. So
I think
Yes.
what I remember in the short time I've been on here was we put things on hold until the court hearing was over.
Oh, that's correct.
And so now it's over. So now, I don't disagree with you, but I would say we have FEMA response by this time. If we don't, we assume
Mhm.
we go with
Mhm.
what the court said.
Mhm.
So.
Yep.
How much time do we need to give them?
Well, yeah, I don't know. if there's a good answer to that question, but at least 30 days, I would suggest.
I'm not saying right or wrong, it doesn't matter to me because it's court order, I'm gonna follow a court order because apparently that's what everybody wants to do. Except certain people, but anyway, but I go back to the point is FEMA has been contacted and they choose not to answer, but even in your rules and regulations, it says can be used for easements. So do you really think they're gonna say no? I mean, even he wants you to ask him, and his lawyer could have done the same thing.
Bill, I'm just trying to rectify.
Well, and I know you are, but
This document that says they have to sign off on it.
But here's the thing, and I'm taking the judge is taking it under his own skin to do it, but I don't see why they wouldn't sign off, don't get me wrong. But.
Well, I don't either.
I don't
There's
either.
hope, and I'm telling you,
I know.
this is just hope that next time I go out there, it's gonna be, no, the county hasn't made up their mind yet, you gotta stay on.
Well, this doesn't affect the easement that was granted by the judge, just for lot.
I agree with you, I agree with you.
This doesn't give Mr. Timmerman permission to block the easement anywhere, doesn't give him permission to block it on lot 6, because he doesn't have any control over lot 6.
But here's what happened, when the law comes out, they say, hey, why don't you and John leave to defuse the thing? And for 30 times, we left the place out. It ain't because this happened or this happened. John and I chose to leave because we was asked to by the law enforcement. We have court orders after court orders. Well, they don't really say bullshit. It says we can get back there and we can do it without harassment. And that wasn't good enough. So anyhow, that's what it's true. False hope.
You're not gonna actually rock it or build anything, are you? You're just driving through there.
Right now, we're just driving through it, but you know, when somebody lays out 3-inch storms, what do you do to get rid of them? Tell me what you do to do that. Of course, he didn't do it. I'm not saying who did it, I don't know. But they're all in the easement right there where you begin it. So, you know, it's one thing right after another.
I know.
We'll work through it.
I think I would like to contact FEMA, but I also will go on record to say, I don't think that will resolve the situation. I think there'll be something else that will come up, but that was his biggest.
There will always. be
Oh, yeah,
a dispute over
absolutely.
this.
That's why I go back to my comment. I
Yeah.
try to stay out of this with a 10-foot pole, but you're gonna get drug in one way or another and it doesn't matter. We're paying for what a previous board did 20 years ago, 15, 20 years ago.
For what?
This
Selling this?
whole thing.
97 is when they sold some of the land. Now, let's be serious. Why would you sell lots in the middle of your land? He's got 3 lots that belong to the county, 2 behind his
Yeah,
house,
that-
and we ain't complaining. But why would you sell lots in the middle of your place?
I can't answer that
Well, let
question.
me
That
answer
was
for you.
something that was done.
Let me answer it for you, because I've heard why.
All right.
Because he was told, well, you're not gonna pay taxes on them. They're in the middle of your thing, who's gonna want them? And who's gonna take care of them? You are. So it's gonna be, you're not paying taxes on them. And you're getting them for free. Well, it kind of backfired him on a little bit when he, and the other 2 it hasn't, just this one it has, because it's one we gotta go across.
We heard you.
And my understanding was, at that time, there was a different access for Mr. Timmerman, or Mr. Pognell or Mr. Schultz, and so there wasn't any dispute with access through this area at that time. For my time, but based on my research.
You don't understand. All right, Kevin, what do you think?
Well, like I said, because the document requires FEMA to sign off on it, I think we should make an attempt to get their signature on this.
Yeah, I don't think it's effective until their signature
Right.
is on it.
So without something from them, I don't know how we can put this into effect. I mean, we could sign it, we could do all this other stuff, but until we have something from them, it's not,
I think that's why I want to see a letter saying, hey, we're trying to contact you.
yeah.
If you fail to respond, we're gonna take that as we don't care. We're gonna do what we want.
And we give it 30 days.
Certified.
Yeah.
Yeah.
And then move forward and make it
At
happen.
that time, we'll move forward with it.
The way I look at it,
I'm fine
trying to
with
be as neutral as
That's what says
possible.
discussion and possible approval, so they don't have to act on it.
that. No, I'm fine with that.
It doesn't even require a table, does it?
No, because you haven't made a motion.
Yeah, okay. So. I know that's not what you want.
No, I'm just saying, I'm gonna have problems no matter what you do, to be right honest with you, it's gonna happen.
It can be a problem.
But-
for
But
us.
also to address.
But I know this is gonna give him, I know this bill, I'm gonna get it here next time.
Fair enough.
To address the one issue he brought up, that the buyouts didn't mean that that covered the taxes on those lots for the rest of their life.
No.
I mean, if they get leased out, they go back on the tax rolls.
Yeah,
Right.
the use is what determines taxation.
Right,
Yeah.
okay. So,
Yeah,
I just didn't wanna be lying to the public,
Sure.
you know.
well, there was never any, when those lots got bought out, that money went to the landowner. It didn't go to the county.
Right.
Correct.
It did
So
not.
what he's saying about, we got tax
Yeah.
money up front, we didn't
Not
get that.
true.
Yeah, it may have flowed through the county, but it went to the homeowner,
Yeah.
property owner.
Okay. I just wanted to clarify that, so. Okay. Well, I guess we will move on to number,
So let's, before we go, who's gonna write the letter?
I'll write the letter.
Okay, and that's fine. I just wanted to make sure we're
And
clear.
send a certified
And-
letter, so we know they got it.
And we got a 30-day,
To the FEMA administrator.
30-day response, which would get us to the very first part of October, or September, I'm sorry.
Our next Tuesday night meeting.
Well, that would be September
Okay.
1st. So do you want to do, we could do September 15th,
That's
put
fine.
this on the next meeting,
Yep,
so
that'd
it'd
be
be
fine.
over 30
Yep,
days.
I just want to make sure.
Then
we're
it's
all on
May
the same
30
page.
meeting.
Good.
Okay.
Sounds good.
So that, 189, 10.
Something
Yes.
Okay. Adam,
Do you need me for anything else?
I don't think so.
No,
Okay.
sheriff's gone now, so we're good.
All right, I'm gonna head out then.
Thank you.
No air?
Yeah.
No air conditioner?
I don't know.
That don't feel like
They
it.
got the air shut off.
I can go check. if You'd like me to?
It's hot.
Oh, good.
Oh, by the way.
Thank
Yeah.
you. What's going on?
Let's check and see if they got the air shut off.
Oh,
It is warm.
it is very warm in here, so thank you.
Oh, hot air.
A lot of hot air in this area.
Yeah, it was all back there by you. Just, the next time we have a public meeting, I think we're gonna start putting stipulations of how long.
Yeah.
Yeah. I think we'll start putting it on all agendas
Yeah.
for.
Huh?
Use the calendar, but that would work.
Need that card like they have if they hold up 1 minute left. You know?
Okay, my item today is a Eastern Iowa Light and Power Cooperatives application for approval of construction on the Louisa County right of way to bore under L Avenue to provide service to 2746 L Avenue, Morningside.
He happened.
You don't have a problem with this?
No,
I'll make a motion to approve Eastern Iowa Light and Power's boring under L Avenue.
I would be happy to give a second.
thank you, Sean.
Mhm.
Okay, we have a motion and a second. Any discussion? If not, all those in favor?
Aye.
Opposed? Carries. I still have a place to sign this.
I think on the back of the first page or the back of the printed one there, so. Do you guys want a secondary roads update while I'm here? Got a couple things going on. So the deck on the K Road Bridge is in poured place. And probably got, I think they're 26 working days left, so probably first week of September by the time they're done. Again, if they overrun it, they'll start paying us back. I'm not sure if it's 1,000 or 1,500 bucks a day, but I think everybody's plan is to get it done, so. Sounds like the DOT is gonna have traffic up on New 61 Newport South right away. It's like August 19th or 20th or something is a plan that I've heard. Maybe a week before, there's gonna be a little bit of a closure on K Road as they do the painting and stuff like that, which I should quit calling it K Road because there's now new highway 78. And then sometime this fall, they're gonna come back and kind of redo the intersection there, because coming down 78 and going up and over, they're gonna make that flat, so that's improvement. It should reduce some of our things there. So hopefully middle of September, we're back to normal and all construction is done and all that, so. Sounds like the DOT's making some progress on the next phase. I talked to Bob Uni a couple, I don't know, last week or so, and he said they're still working on it. Again, but maybe his schedule a little more optimistic than mine, but anyway, so they're working on it, so.
Working on what? I didn't hear that.
They are working on right of way and plans and everything for the next section. So just talking like 4 years or so, if it would all be done. This next section, of course, it isn't the,
To Waplo.
yeah, so
Believe that one.
that's kind of my opinion on it, but it is what it is, so.
You think it will be done in 4 years?
They think it,
That's just a Waplo.
they think it'll be paved up to Wapello in 4 years.
Even bought right away.
I don't know.
That in a minute, we'd like to have that.
Yeah, so again, I'm a little skeptical, but if it happens, great, so. Other than that, we're, busy doing our things out there. I did get a notice, yesterday that the salt that we typically buy 2 years ago was $95 a ton. It was now $105, or last year it was $105 and I complained about that. Now it's $137 a ton. So, I'm gonna buy a little bit less and try to use it a little more sparingly if we can, because it's just going to continue to increase. So
We're not gonna have any snow or ice.
salt and rock and equipment and everything else. I authorized a truck box and wings and all that for the truck that were in fiscal 27. The truck box won't come until January of 2028. So that's how weird the world is now, so. Yes, it is what it is. All right, that's all I have to say. Any questions out there? Yes.
I have a comment.
Yes.
As long as you're talking to the DOT. With the 60-mile-an-hour being established like on 78,
Mhm.
when you come to 61 and you turn north or south off 78, there's no signage
Yes.
saying what the speed limit is.
Yes. Did I copy you on that? I got an email from the DOT a couple, like a week ago. I forwarded to Brandon, and the reason that 61 and 70 are both still 55 is because of the crash history on there, so. Which makes sense.
I agree, they even put up some signage because they were setting people up for failure.
Yeah,
Yeah, because of
I get my doors blown off on that one, I go
Yeah,
broke.
they run pretty hard.
yeah. There's also talk, if you, let's say you were turn off onto the golf course road. And our speed limit is 60 and theirs is 55, and I'm like, let's not go putting a bunch of signs there everywhere. I mean, it is what it is. Odds are you're not getting a ticket if you're going 62 anyway, so. If you're going 67, not or 68, that's, you're on the way to the next convenience, but, so.
I just thought we were coming off a 60-mile-an-hour road like 78 on them.
Yeah.
61.
68's pretty spicy on the golf course road.
It is, it is,
Spend a
it
little
is,
driving.
it is. I have been out driving roads and looking at curves. Almost all of ours were signed pretty conservatively, so I don't think there's gonna be a lot of changes. There's a little bit up there on X17 south of Columbus Junction, but we're working on it, so.
Well, we're at 60 on all the county roads, so
We are 60 unless signed otherwise. There's some, residential areas where it's less or in town and things like that, so.
Any update on Rockport? Have they said anything about what's happening?
Heard lots of things. There's been talk of a land swap and some other things going on. I don't know that River Products is listening, but they're still charging us at the older rate, so I'm not like squeaking about it right now. I assume that's gonna end
We'll hope the bear.
and at some point. I have had some other rock quarries interested in getting some more work, so we'll see how that goes, so. Other than that, I'm, see, listen to the rest, so,
Great, you know, this back.
Thank you.
yeah, I suppose.
Okay. So, well, you up there.
Yes.
Okay, that's a big call. So we're at 13, which is opening bids for
Getting there.
LP.
Just open them up. And hand them down. I think we only got what, 2?
Yeah.
Like the only two we have, Agriland and Farmville.
No, no. You must put that as too. It's a board thing. And
Man.
Yeah, you still do it.
Tough hell, John's running
People who did, so, you know.
I understand that. You still have the pool, you still have to have a person.
Okay.
These people want.
Agriland is pleased to offer a transport load contract of $1.035 down.
How much?
Dollar, three and a half.
$3.50.
Yeah.
On the elevator,
Ain't gonna do it.
we'll put in a bid of $1 even. There you go.
That's what they quoted me on.
Might as well hire nine.
You know, you
Better
remember
what I
what it
thought we
was last
might
year?
be at.
What's that?
You remember what it was last year?
I do not.
I do not, I'm sorry. I can.
I
give
think
that
it was a little, I
information at
think
the
it was
next
a little
meeting.
more than that. I think,
Yeah, I thought it was a little time that last year, but I don't remember.
yeah, I don't remember them, sure, but I know it was more than that.
Well, you wanna move on to number 14, Kevin?
Yes,
I will make a motion to accept the bid from Farmers Elevator at $1 a gallon.
I'll second that.
motion second, any further discussion? All in favor,
Aye.
opposed? You need the envelopes.
I need the big envelope, the minute.
Yeah, I wonder if I,
Yeah.
but I could tack a couple.
Yeah, I just,
Okay, open bids for the roof crickets at the complex, do we have more than one?
No,
Oh,
Same one we had before?
yes,
I made that easy.
And that is from T&K Roofing, is that correct?
Well, we tried. Yeah,
yeah. Well, you do.
Don't have any cricket.
we're making the same.
I
we
have
did try.
tried.
Yeah.
It's on the website.
Yeah, that's fine.
I can't believe I'm getting much. I need to pick all the envelopes.
18,000 something, I don't remember the exact
You
number.
need to have this over there in their desk.
I probably got one. So the bid is $16,400.
I think it's important that we get that done. I'm gonna go ahead and make a motion to accept that bid.
I'll second that.
Motion and second, any further discussion? In favor,
Aye.
opposed? Okay. Review payroll changes, have you gentlemen had a chance to look at those? Yeah.
Yeah.
I did think they were. We got a part-time cook. At $20 an hour, we got, I think the other. This Brandy Cox, is that she's leaving?
Yeah, resignation.
And then the step raise.
Thank you.
Okay, we already did meetings attended. Discussion and possible action, I don't know if you remember our discussion on this before. Iowa Ports, Eastern Iowa Port Association wanted us to kick in $2,500 for a lifetime membership. I think, if I remember the discussion right.
I'm not on board.
No, I'm bored with
That
so-
was fed to us as a, all expenses will be paid by the federal government, you're just in here as a group for your
Yeah.
voice, and now it's turned into membership fees, and I know they said it's a one-time buy-in, but until that changes, and then all of a sudden we got a yearly thing, and
Does that guy get a salary?
I don't know that anybody on Eastern Iowa Ports, but there's also the Iowa Ports Authority, and those people may get.
Is that the one with, the guy that used to work for the Corps of Engineers? Which one's that?
I don't know. Jim Irwin is the supervisor, so I,
Yeah, and the Eastern Iowa is made up of supervisors. But the Iowa Ports
Port
Authority
Authority.
is its own entity, so, and they're helping get the Eastern Iowa Ports Authority off the ground. So, anyway, good,
yeah.
I guess make a motion,
Well, I don't think we have to do anything.
don't have to do anything,
Just
okay.
disregard it as far as I'm concerned.
You go to your meeting though, and for some reason, we're the only ones who can explain our position, I guess, and,
Yeah,
you know, we know we're gonna have some issues this budget season, so we need to watch it anyway, so.
okay, moving on to item 20, public input for people that would like to be on the next agenda.
I don't have anything for the next agenda. I just want to let you know that the Iowans for tax relief have an overwhelming majority of 72% of Iowans supporting the 2% cap on total property taxes. And I believe there's a lot of people, or your constituents in Louisa County feel the same way. So that's all I have to say. Thank you.
I would like to add something to that.
Okay,
The islands for tax reliefs, political postings on that often do not mention the effects of the exemptions. And those are gonna be the immediate budgetary drops for us all. And I don't know that the average taxpayer knows that, so just adding it into the mix. So.
yes, changing them from credits to exemptions mean that we no longer have state backfill on homestead, senior, or veteran property tax discounts, so.
Then that's gonna double whammy the roads, the money that comes back in too.
Well, it could potentially lower the valuations of our counties by 20-some%.
Yeah.
And that's,
And then I also read where the fastest growing demographic in Iowa is 60 years and older.
Yeah.
So that's gonna complicate the issue because they're all gonna qualify for discounts.
There are states that don't have any property tax, so I mean, where do they get their income? I don't know.
sales tax, visitors,
Yeah,
Well,
most of those states are huge tourism states, so.
they go to where they get their money, though.
well, I was in Chicago last week and the sales tax was 10.25%, so.
Boy. You wouldn't expect anything less, would you?
Well, I don't know, but
I think we ought to, not petition the legislature, but to get our credit card money we spend and cash we spend out of county sent back to this county, but their computers, it's very easy to do that.
I got,
Very easy, and we need to,
It's not a very popular.
not in
They
the
don't
counties,
want
it's
to.
not, no, it's not, but
is
It's
that
gonna
Mr.
take money.
Collins and Mr. Lofgren willing to introduce
I don't know.
legislation on that
I don't
as
know.
well?
It's
I
it's
don't-
gonna take money away from the bigger cities. And there's gonna be plenty of opposition from them.
oh, I'm sure there will be, and probably not enough to pass it, but it all
Yeah.
makes sense. So
Yeah.
maybe we should start buying everything on Amazon then.
Don't tell my wife that.
Very good.
That truck's my driveway every day already.
It would come in the White House.
Yeah.
Well, that maybe it was helping, we don't know it.
Yeah.
But I have talked with Mr. Collins on that and asked if they would work on the legislation for that this coming
The
session.
email I read didn't seem like he was very receptive in that one, but, you know,
But I talked to him again.
yeah, okay, I can appreciate it.
If you'd like.
Yeah,
But I would add that no amount of sales tax is gonna make up for the
No.
property tax
No.
losses in the county like ours. So it just
you know.
doesn't work out that way.
But it's just, I would guess probably between 80 and 90.
You're just talking about the loss.
I'm talking about the loss of taxable value in the county due to the credits. The estimates are 20% is
Up to 28%.
$250,000 in
I
revenue.
thought you said 3/4 last time.
Or I'm sorry, I missed up 3/4 of a million, roughly.
And I've talked to other counties and they're all feeling the same way,
Yeah.
so. Um,
And I'm sure there's not gonna be a lot of, folks out there asking for less rock or less police or.
Get that target.
I'm not thinking. Anyway.
You need to talk to that engineer and see how they got it done in Illinois.
10% sales tax is how they got it done.
Any other county employees that want to give us some information?
That's not a bad idea.
Not tonight. If not, I would look for a motion to adjourn.
I'll make a motion to adjourn.
I don't know, I'm having a lot of fun.
Are you?
Yeah, but I'll give a second.
Well, we should bring popcorn.
Yeah, don't tell me, I've done that before.